Hey everybody, welcome to our lunchtime webinar series. Today we're going to be covering ketamine, psilocybin, and new drug therapies. And with us today I have Jesse Mondre out of our Portland office in Oregon, my partner Vince Sliwoski, also out of Portland, Oregon, and my colleague Griffen Thorne, who is with me in the city of Los Angeles on this hot summer day. This is going to be a very interesting webinar. Our law firm, really, our expertise is in these kind of emerging marketplaces. We're very well known for cannabis, regulated cannabis products and licensing in a variety of states. So it's a natural point of focus for us to look at these other new drug therapies and emerging medicines as they come up in the US and individually in states and cities. Some of you may be thinking that cannabis, its federal illegality, inevitable legalization, its statewide legalization is pretty comparable to how some of these new drug therapies are coming to light, being legalized, administered, and distributed across consumers, physicians, etc. That is not necessarily the case. Some of these new drug therapies are following the cannabis trajectory fairly closely. Others actually are pretty well established and really constitute off-label use. They're already heavily regulated, and really the emerging part of it is the administration of the drug for different kinds of acute illnesses and ailments. And today, we're going to go through some of these new drug therapies, and at least what we're seeing in our offices across the West Coast, as far as the progress legally for how these new drug therapies are being treated, with a specific focus, obviously, on ketamine and psilocybin, which are picking up serious steam across consumer markets, politically and legally. The format of this particular webinar, what we really come to like, is more of a Q&A session with the panelists. We don't really do prepared speeches or canned speeches. We think it's very helpful for viewers to answer not only your questions, but the questions that we have for each other, so that we can get to know these areas a little better. And I'm the moderator today. I'm not going to be formally presenting, but I will do my very best to get at everybody's questions that are relevant to the topic. Also, continuing with our lunchtime webinar series, don't forget, on August 5th, coming up, the next webinar is going to be trending topics in cannabis litigation, which is going to be handled by our litigators, another very hot topic. So don't miss our next lunchtime webinar on August 5th, in about a month. So without further ado, what we're going to touch on first, and we're kind of going to bounce around a little bit, we're going to talk about psilocybin. And psilocybin is very exciting for us. This really is a drug therapy, a treatment, an emerging medicine that is way more similar to cannabis than not when it comes to its legalization, at least its decriminalization. It's taking a bit of a different form in how it's getting there. But luckily today we have two Oregon practitioners in Oregon very seriously is contemplating legalizing and commercializing psilocybin, I think this coming fall. But to talk about psilocybin, generally its legal status, I'm actually going to start with Griffen. And just so everybody knows, Griffen is having some technical difficulties with his internet. He did call in on the phone, so even if we lose him on the broadcast, you should still be able to hear him. There may be a delay between the audio and the visual, but it's not going to be fatal. So Griffen, what is psilocybin? And what is it actually used for at this point?
So, and yes, I apologize if there's any sort of delay between my voice and the screen. But so psilocybin is a chemical found in certain psychedelic mushrooms. It has psychedelic effects, sort of like other drugs, LSD, ayahuasca, things like that. It is illegal in the United States under the Controlled Substances Act and analogous laws in all states in the United States. So it has no legal use presently, although people are starting to look at it as a potential to treat certain mental disorders and other similar illnesses and diseases. And as Vince is going to touch on soon, there's a research sponsored or under the guise of the FDA that's taking place.
And what about international treatment of psilocybin, generally speaking? And this is where we start to see kind of this intersection between the treatment of cannabis and a drug like psilocybin, where not every country is maybe signed on to strict prohibition, at least regarding cannabis. Is it the same for other countries with psilocybin?
It's similar. There's an international treaty, the Convention on Psychotropic Substances in 1971, that was signed in 1971, and so countries that are signatory to that treaty enforce laws very rigorously against psilocybin. That said, there are a lot of places on Earth where you could find psilocybin or similar psychedelic drugs sort of legally. There's sort of a cottage market for people who do tourism to countries in certain parts of the world where you can take these drugs. And it's not available here yet, but there are places where it is not regulated, like in the United States.
So in the Goop documentary on Netflix, when Gwyneth Paltrow sends half the staff down to Jamaica or a place in the Caribbean where they're using psilocybin for treatment, she's not going to get hauled off to jail necessarily for doing that.
Well, it's complicated, but it involves multiple countries' laws. Yeah.
Everybody should watch that documentary. It's very curious. All right, Griffen, back to business. What cities and states, and this is very important because we're seeing different treatment literally across the United States. And what's very interesting is that municipalities are getting involved, which again, very similar to cannabis, where we had early movers that were willing to decriminalize cannabis, maybe not commercialize it. But what are you seeing with psilocybin really nationally at a municipal level? What's going on out there?
Well, I think it's a little bit different from cannabis in that it's not happening so far on a state level approach. I mean, we've seen a few cities and counties. Denver was the first one last year. Santa Cruz, Oakland followed suit. Actually, Oakland was much broader and included a whole host of plant-based psychedelics in its decriminalization resolution. But basically, what's happening is a few cities have opted for decriminalization. And I want to be clear when we talk about this, that there's a big difference between decriminalization and legalization. I think people a lot of the time mix these two things up. Decriminalization does not mean what it sounds like necessarily. It doesn't mean that something is no longer criminally illegal. It just means that law enforcement is directed not to use its resources enforcing the law. So in Denver, for example, where psilocybin was decriminalized last year, all that really happened was the city council or county council said, hey, law enforcement, don't make it a priority to enforce these criminal laws. They still theoretically could do that if they wanted to, but it just sort of shrinks that effort. Query whether or not that's effective. There's been a lot of studies, especially with marijuana, over the past decade about how decriminalization isn't as effective. But at the end of the day, it's a good step in the right direction. What these decriminalization measures, though, have done basically is not to create the kind of commercial market you'll see with medical marijuana, for example, but really they just say, hey, if you're in possession of certain amounts of this, you're probably not going to be arrested, or at least it's going to be a low enforcement priority. It doesn't necessarily give the green light for someone to open up a mushroom dispensary or something like that. But very recently, there was an effort, and Vince is going to talk about this shortly, to legalize mushrooms for certain uses throughout the state of Oregon. That is going to be voted on, I think, in the fall. The state of Colorado probably will pursue something similar in 2022, and other states, of course, will follow suit.
Is there anywhere today in the United States where I can set up a mushroom business legally, get a license to sell mushrooms, psilocybin, link up with physicians lawfully, joint venture with them if possible, to really start a business? Does that exist anywhere in the U.S. legally at this point?
Not yet. No.
Okay, thanks for clarifying. Vince, let's move on to you. This is a very interesting question. I always get a little afraid and sweaty when we start talking about the Food and Drug Administration. We know, though, the power that they wield by statute, by regulation, and even though psilocybin may be Schedule 1, that does not necessarily prohibit it becoming an active ingredient in drugs that are approved by the FDA. And we've seen that with cannabis, with Epidiolex, and it's certainly not the only drug out there that's got a cannabis compound. Many people are trying to get cannabis-oriented drugs across the finish line with the FDA. It's very expensive. It's very difficult to do. It can take decades to accomplish. Are there any FDA-approved psilocybin drugs on the market, headed to the market, pending, that you know of?
Yeah, so good question. So there are no drugs on the market today, but there may be soon. And I think you're right. Psilocybin is a Schedule 1 controlled substance. That means it is harder to study, but it can still be studied. And FDA is very interested, I would say, in the potential of psilocybin to combat different depression spectrum disorders. So the two drugs that are currently being routed through FDA that are psilocybin drugs are to treat treatment-resistant depression that is said to affect 17 million Americans, and then major depressive disorder, which is something that we just colloquially refer to as depression, and that is said to affect 5 million Americans. And who knows, those numbers could be higher now in the time of COVID. But FDA has a special status that it can award to drug applicants. It's called a breakthrough therapy designation. It did that with ketamine, which Griffen's going to talk about a little more shortly, and that's how this drug Spravato came to market last year. That's a nasal spray ketamine antidote for treatment-resistant depression, right? So that one's on the market, and psilocybin drugs are close behind. A bit more on that breakthrough therapy status, just so people understand what it is. It's really designed to sort of expedite the development and review of drugs. So it's given out by FDA only for therapies that have shown strong preliminary evidence in treating serious medical conditions. It puts those pharmaceuticals or compounds on a fast track for approval. And the FDA works carefully with those drug companies and off intensive guidance throughout the process. So right now, the two drugs that I've been referring to, one is being put forth by a company called Compass Pathways. They've been kind of visible as to their FDA efforts and their patent USPTO efforts going back at least a couple of years. Compass is an interesting company. It's a for-profit, privately held, venture capital-backed company. It's likely going to go public someday, but it's not public now. And although they've taken on heavy investment, most people can't buy a membership interest in Compass or stock in Compass. Right now at FDA, they're running a 216-patient phase 2B clinical trial. I'm not going to get into like what all the different FDA trial protocols are, because you guys would all glaze over, but you should know that it's typically the second to last stage before a drug gets FDA's nod and can go to market. And Compass supposedly will be ready if and when that happens. They say they've made enough doses of the drug to supply more than 30,000 patients already. So the Compass compound is used in conjunction with talk therapy is to treat treatment-resistant depression. They have a patent I mentioned, and the patent is for the compound, but it's also a patent for a process. It's a compound to be used in conjunction with a form of talk therapy. Preliminary studies have shown that psilocybin dosing has shown the most promising preliminary effect in treating depressive disorders when it's used in conjunction with talk therapy. So we're monitoring it closely. In my view, that drug, if it's approved, is probably at least a year or two away, but it's getting close. The second outfit to receive FDA breakthrough therapy status is something called USANA Institute. That's not to be confused with USANA, the multi-level marketing company that also sells all kinds of herbal supplements and treatment type wares, I guess I'd say. But the one that I'm talking about now, USANA Institute, is a nonprofit medical research group. So it's a lot different in orientation than Compass Pathways. And they have a stated mission of understanding the therapeutic effects of conscious expanding medicines. USANA also has a breakthrough status designation, and they also have a phase 2 trial underway. Their approach is different than Compass in that the treatment being tested, the drug being tested at FDA there is just a single one-time oral dose of psilocybin. And they're not targeting treatment-resistant depression. That company is targeting major depressive disorder, or what we just commonly call depression. So that's it. That's what's currently out there with FDA. Looks promising. Looks like, as we saw with Spravato, we will see a psychedelic drug come to market soon, but in the psilocybin protocol. And like I said, my best guess is we're about a year or two away.
And even if we see a pharma-grade psilocybin-oriented drug come to market to treat patients, probably going to be prescription-based, I assume, because to be safe, it'll have to be under the supervision of a physician, given that it's a Schedule 1 impacted drug. Is this going to eliminate the marketplace for maybe over-the-counter psilocybin in states like Oregon or other states that decide not only to decrim and legalize, but to commercialize it with licensing and operational protocols?
Yeah, that's a really interesting question. There's going to be some overlap. The way, Jesse and I are about to talk about what Oregon is doing here, but the way Oregon has it set up is a little different. For instance, as I understand it, patients or people who want to use psilocybin in the state at the treatment centers don't necessarily have to have some sort of underlying qualifying medical condition. They don't need to be diagnosed with a physician for something like major depressive disorder or some anxiety spectrum disorder or anything like that. They can just go and, in sort of more of a wellness concept type approach, use psilocybin in accordance with the Oregon program. These FDA drugs are different. This is like compounding pharmacy type stuff where you're getting a capsule or a pill. It's being administered through a physician's prescription, and it's being given to you at a pharmacy like other controlled substances. So, I envision it someday as two-track type thing. Right now with cannabis, you've been making cannabis comparisons. You can get your Epidiolex if you have a qualifying condition for that, seizures namely, and use cannabis in that way. Or you can be like the rest of the general public in a lot of these cannabis legal states who buys cannabis over the counter essentially and doesn't have necessarily a qualifying medical condition. So we'll probably see it play out, something like that.
It's fascinating. And again, another parallel, even with cannabidiol, where we have the pharma grade track that's very formal, occupied, patent driven, very serious. And then we have over the counter with really lay people in the wellness market. So it's going to be very interesting to see how that plays out politically and legally. Before we move on to the specifics in Oregon, and frankly, folks, there's a very good chance that the Oregon initiative is the blueprint for the rest of the states. The same thing basically happened with cannabis legalization on an initiative basis. We're getting some very good and interesting questions from our entrepreneurial folks, which we love. Even though you can't legally vend psilocybin in a corporate structure with investors, et cetera, in these cities that have decriminalized maybe small amounts, so you can possess the drug, but you cannot lawfully get a hold of it. What about testing centers, established testing organizations, chemical researchers? What can they do? What are they running up against if they come into possession of psilocybin in, let's say, Oakland, that was given as an example? Are they going to be running afoul of the law if they take and test the psilocybin? Don't necessarily know what they'll do with the results, but is that going to run afoul of just decriminalization in a place like Oakland or these other cities that have decriminalized? Anybody is free to answer that question.
I can try. The FDA stuff is obviously under licensure and in coordination with DEA and all that. So companies like Compass and USONA don't have a problem there. A lot of the research is being done overseas in jurisdictions that seem more hospitable or friendly, like MindMed, who's a big player in this space, tends to advertise and I think do the research over in Switzerland. A lot of our clients who are into this stuff, especially all of these like publicly traded Canadian companies, are entering into joint ventures and research protocol type agreements down in the Caribbean. Countries like that, where you mentioned Jamaica early on, there's sort of a local tolerance governmentally for the administration and the use and I guess the research into psilocybin. So yeah, I mean, if you were to do something like that, a big research product without any sort of DEA or FDA approval in a jurisdiction like Denver or Santa Barbara or Santa Clara, I can't remember where you said it was, you'd be running afoul of laws. You'd be running afoul of federal laws and probably state laws to some extent. So it really is kind of a question of how you're set up in the first place.
Got it. Okay. Well, let's move on to Oregon, because Oregon is about the only state that we have to work with substantively that's on the precipice of actual legalization, licensing, and developing these patient networks. And this is for both Vince and Jesse. Please have at it, take your time, explain this Oregon initiative, because we're probably going to see it again and again with states that are interested in this drug therapy.
Yeah, sure. I can start, I think. I'm going to refer to the Oregon law as IP 34 quite often. That's because it was an initiative petition, that's the IP, and it's IP 34. So it's a ballot initiative that the designers had to essentially go out and get signatures for, and they've collected enough signatures where it looks like it's going to be on the ballot for Oregon voters this fall. And so when we talk about IP34, I think it's really key to look at what it's doing and what it's not doing. And what IP34 isn't is a broad legalization of psilocybin for recreational purposes. It's not going to be under this law available for to take home or in stores. You're not going to be able to market or brand products to the general public. The IP4 is really 34 is really written to approve psilocybin in licensed therapeutic settings, and through a framework of regulations that's going to be established by the Oregon Health Authority. So, if the next sort of stage is, okay, well, if this measure passes, sort of what happens next? And it's not going to be sort of the regulatory framework of what's in IP34 isn't set right up so that people will be able to rush out and start putting in applications for licenses to manufacture products or to run clinics or anything like that. What the IP34 actually does is establish a sort of a 2-year program and an Oregon Psilocybin Advisory Board that has about 16 to 18 people that will be appointed by the government, whose job over the next 2 years is to sort of study this and develop regulations to put in place a framework so that at the conclusion of which there can be a process by which everybody from the patient-facing care provider to the manufacturer of a psilocybin product can apply for licenses and go through that process. And that will govern the manufacture, transportation, delivery, sale, all of these sort of things along those lines. That's sort of the broad brushstrokes of what the law does. And Vince, there's some other important things we could talk about there. I think one of the things that's important about the law is that when you start diving into it, there's going to be residency requirements in Oregon, and there's also going to be some certain limits on the number of licenses that a person can have. I think if the law is written or would become, you can only have one manufacturing license, and you can't have a financial interest in more than 5 of what they're going to call like a psilocybin facilitation clinic. And so there's going to be some certain limits on the size and the scope of what you can do once this finally comes down the pike. That I think is going to be different than what we saw in cannabis, especially what we're seeing in now with the growth of multi-state operators. Now, this is really designed to start as a sort of a local therapeutic-based program rather than maybe sort of that gold rush mentality we saw with recreational marijuana.
Yeah, I mean, that's pretty good coverage, and we could really get into the weeds on it. And if anybody's interested, it's a very long sort of petition, and it's well thought out, and there are a lot of rules associated with it. I think the only really broad concept I'd pile on to what Jesse said is that it isn't a mass decriminalization thing. So a lot of times people say, oh, wow, psilocybin's about to be legalized in Oregon. Not really. It's going to be legalized in the context of these limited service centers, but, the day after this thing becomes law, if it goes through and you're walking around downtown Portland with a couple of mushroom caps in your pocket, that's still not allowed, right? It's not been decriminalized. There's a companion initiative to do that. It's an unrelated initiative, I should really say. But people shouldn't be under the impression that grow at home is okay now in Oregon, or distributing to your friends is okay in Oregon, or buying at these clinics and taking it home and selling it, or whatever. None of that stuff is allowed. It's not a decriminalization. Right. And unlike the early medical marijuana program stuff, which established sort of an affirmative defense to state prosecution for possession of cannabis as a controlled substance, we won't have that with psilocybin. It really, really is like a heavily medically, professionally administered, oriented type of program.
Right. A couple more things on that note is that a couple other things that people should know about is that the law is specifically written that, it's not going to fall under medical insurance, and health insurance providers are not required to cover this. It's not going to provide protection in the employment context. So, if you're out there and you're taking some mushrooms and you test positive for this in the employment setting, that's not going to provide you protection. You're not going to be able to use that as a defense. So there's some things like that. It doesn't sort of try to provide an exculpation for the violation of federal law, which, obviously a state law couldn't really do that anyway, but, it sets that out really clearly. So I think it is really a measured approach that I think harkens back to really the early days, going back to, the 90s with the beginnings of the legalization of marijuana, I think. And then that's sort of a baby step move, but it's a really important step. And I think it can serve as a good model for jurisdictions around the country. We're looking at this.
And Jesse, you mentioned, oh, sorry, Vince. You mentioned a residency requirement. You mentioned financial caps, ownership caps. This is all very familiar to us in the state-by-state cannabis legalization movement. To keep it cottage, to keep big money out, to keep VC and PE money out. That's one of the driving factors behind those policy decisions. Plus, the federal government is on the back of the states, given cannabis's illegality. In IP34, what were some of the strategic decisions that the IP34 promoters made, and what have they left kind of subject to regulation? Are there things like local approval, local opt-out, other barriers to entry that are super cottage to promote Oregonian business owners? What are we looking at in that realm that might be similar to cannabis, so our viewers can chew on that?
Yeah, sure. Another one of the big things that's out in the bill is the requirement to obtain a Lux. And so I think that's something that is going to take that statewide sort of ability to apply for a license and put a lot of hands into, the local control board. So everybody who wants to apply for a manufacturing permit or to operate a psilocybin facility is going to have to apply for a land use compatibility statement. That's going to really happen at the county level. And so that's one of the ways that the designers of this bill are trying to sort of cabin the scope of it and give the local jurisdictions a lot of control into how and whether these kinds of clinics come into their jurisdictions. There's also provisions, about how close they can be to schools and what the distances between them and things like that. So I think, these are also things that we're pretty familiar with and we see quite a bit in the cannabis space. And I think the drafters of this bill really look to that and sort of try to see, what worked and what didn't work in this. And I think what they really did is try to cabin and limit how the growth of this industry, so that this is not going to be, maybe an explosion right off the bat, but that it's going to be able to be tightly controlled under this development period, and then the few years following it. But a lot is left up to the OHA and to this board to define regulation. There's going to be, I think, pretty significant regulations on who it is that's going to be allowed to operate as what a psilocybin facilitator, i.e. the person that you're going to work with when I'm a guy off the street and I walk into a clinic and I want to, for whatever reason, wellness reason or other reason, I want to, partake in this medicine or this therapy, that there's going to be a process set forth. So it's not really going to operate to sort of just as a de facto dispensary under the guise of a licensed therapeutic center. So that's, I think, a couple important points about it.
The other thing that they did that's strategically sort of interesting is just they're slow walking in terms of not only the substance of what they're allowing people to do, but just the timing of it all. Jesse's been referring to that OHA group. I can't remember what it's called, a council or director group or something like that, but they're essentially going to talk for a couple of years, right? So if people vote in November to pass this initiative and it becomes codified into statute, then this working group gets together. And they talk and they figure out best practices and recommendations and all things, and nothing happens until 2023. That's when license applications begin, January of 2023. So when are you going to Psilocybin Service Center actually open in Oregon, and when can you go in there and purchase psychedelic mushrooms and have a session and all of that? 2023, mid-2023 at the earliest. It's going to be a while. And it's a slow walk thing. It's slow walk in terms of what you're allowed to do, and it's slow walk and when you're allowed to do it. And that might be smart. I mean, it's cautious, right? It's not broad decriminalization, anything goes, home grow, all that stuff we've been talking about. And as an aside, if people are interested in how that might end up working in Oregon, they should also track IP44. That's a separate petition focused on decriminalization of all drugs, right? So it removes criminal penalties for small amounts of personal possessions of drugs, and it classifies those penalties actually as Class E misdemeanors, which is super, super low level, and directs people to drug treatment and recovery services, whether you're talking about heroin or psilocybin or any other type of drug. More similar to what Oregon did for small amounts of possession is cannabis as a controlled substance as far back as 1973. So that'll have some interplay with what happens with psilocybin. But I think overall people should think of the psilocybin IP34 as well drafted, cautious, maybe likely to pass for those reasons, and don't expect any big developments on the ground anytime soon.
And Jesse, we have a clarifying question from a viewer. Can you tell us again what the land use compatibility document is?
Sure. They may go under different names in different jurisdictions, but here in Oregon, a land use compatibility statement essentially is a document by which a county zoning board decides if the use that you're going to put this property to is compatible with the zoning requirements of the land. That's really a way to think of this, is that a county might zone certain areas residential, commercial, or industrial, and what a land use compatibility statement is something that's going to be prepared by the applicant or by the licensee if they're trying to open up another center or something like that, to say that how this use of the property is going to be compatible with the county zoning regulations, so that it meets all of the requirements. For example, that maybe you've got to be 1,000 feet from a school and a church, or you've got to have access to X number of parking spaces, and all the way down the board. This is a way that anybody who's really opening any kind of business has to look into something like this, and it's going to be no different here. And we saw this with marijuana, and one of the big battles there, of course, was the pot versus Pinot controversy, right? Where you've got people trying to go marijuana next to wine grapes, and arguments over whether these kinds of uses are compatible with the purposes of, I guess, with the vision of the county and the way they've done their land regulations, their land use regulations. Vince, do you have anything to add? I know you've worked on quite a number of looks over the years, but
I could, but we've got a half hour to go. I think that's probably a good answer to that person's question.
Yeah, I think it's fair to say that we're not going to see psilocybin treatment centers on Main Street next to the U.S. Post Office, by the yoga studio. It seems it's going to have a very different fate than what cannabis has seen in the dispensary setting. We had a question whether it would be more comparable to the ketamine setting, which in all states, only a physician-to-own company, corporation, depending on state law, anti-corporate practice of medicine regulations, could administer ketamine in that setting, and it is in no way similar to a dispensary. Sounds like psilocybin could end up being a hybrid, but probably leaning more towards the clinical model. And one question that we have here, and I think it's a very good question, because we are a business law firm. We help entrepreneurs from startups, soup to nuts, legacy clients that are very large now, that have been operational for years, and all sectors of business and industry. What are the business opportunities going to be in Oregon? And what are companies doing right now to position themselves to take advantage of this opportunity, from intellectual property to equipment, hardware, you name it? We've seen it before in the ancillary space. What's it looking like for psilocybin in Oregon?
I think it's a little bit too early to say exactly, what it's going to look like. But I think there are opportunities out there for people who want to be ahead of the curve, and that's going to be things like, getting involved with and tracking what the Oregon Psilocybin Advisory Board is going to do, trying to direct these regulations along a sort of a route that's going to make this profitable or a business opportunity. I think there's going to be a significant amount of opportunities on the manufacturing side of things, and I think that people who are looking into this start, making plans now and start building business models and developing, starting to develop teams that are going to work within the regulatory structure that's set out by the statute. That's going to be fixed because whatever regulations the OHA comes up with won't alter what's in the statute, and they'll work along those lines. I think this is a time to really start building partnerships and to look at, how you can structure and invest these businesses, invest into these businesses within the limits of, say, you can have a financialist in 5 clinics, but you can't own 10. Where are the places that you can do this? How do you want to do this? And to start talking to your business partners and your corporate counsel on how to get yourself ready for 2023.
Yeah, it's a great answer. I don't have much to add, but there are going to be market opportunities. I mean, there are 4 classes of licenses. People are going to own them. People are going to start growing psilocybin. People are going to start selling it through to retail. People are going to make money off of administering services, qualified professionals. There's a market there. It's going to be a heavily regulated market, and it's going to be somewhat monopolistic. So it's going to be a thing where if you get one of those licenses in a jurisdiction that allows it, that doesn't opt out, as most of the jurisdictions west of the Cascades will probably do, you may have a good opportunity there. And I think Jesse's advice is really, really good, to keep your ear to the ground, go to those meetings. They'll all be public meetings with that board once it's convened, and try to steer it and try to give input. And you will be ready to roll on January 4th, 2023, when they take your application.
And you've heard it here, folks, January 4th, 2023, that's when applications are going to go in for licenses, which means in the 3 years, 2.5 years, 3 years leading up to that moment, there's going to be some pretty aggressive rulemaking going on with the OHA in Oregon. So find your lobbyists, get your bulldog policy people into the legislature, into those agencies, that agency in particular, to build the regulations, because they have an insane amount of power. And that's not just going to be in the rulemaking phase, it's also how they interpret the rules, which we all know, depending on the person that you get on the other end of the phone in Salem, you may get a different interpretation than what you think the law actually says. So don't sit on your hands. I don't know about you two, Jesse and Vince, but I assume that this is going to pass in November. Do you guys agree?
Yeah, fingers crossed.
Okay,
yeah, I'm hopeful.
Right.
Yeah, very hopeful.
I think it will now. At first I didn't. A couple of years ago I was skeptical, but I think it was written cautiously enough, and it was amazing how many signatures they collected, even in the face of COVID. And it's medical treatment. That's all it is. And it's so heavily regulated. I think a lot of people will be won over by that.
Super interesting. Stay tuned, folks, for psilocybin in Oregon. Okay, moving into the ketamine phase of this presentation, and this is an area where I've actually worked alongside Griffen. We're seeing a crazy uptick in ketamine clients, basically folks who want to JV with physicians when possible, also that want to deal with the intellectual property around these ketamine infusion treatments. Ketamine is wildly different than psilocybin and cannabis, but it is still an emerging drug therapy with multiple off-label applications for all kinds of ailments, mood disorders, depression. It seems like something new is coming up every day where this is a viable treatment. It is not a Schedule 1, and I'm not going to steal Griffen's thunder because Griffen's going to give us the ketamine breakdown. Griffen, what is ketamine? What's it used for, and how is it regulated currently in the United States?
Okay, so everything we've talked about up until now is really related to plant medicine. We talk about cannabis, we talk about psilocybin, technically, I guess, can be classified as that. Ketamine is different completely. It is a drug that has traditionally been used for anesthetic purposes, pain relief, and more recently for certain mental disorders. It can be dangerous if not taken correctly and can have side effects, including things like hallucination in some cases. So some people actually classify it as a psychedelic, but it really, to date, has been used traditionally in medical settings, except for unlawful uses. Currently, it's on Schedule 3 of the Federal Controlled Substances Act. So for reference, both cannabis and psilocybin and things like heroin are on Schedule 1 in the eyes of the federal government. They're the most dangerous drugs on the planet Earth. Very different from ketamine, though, which is on Schedule 3, meaning it's considered to have only a moderate to low potential for physical and psychological dependence. I'll let people make the judgment calls that they will as to whether or not it is, in fact, more dangerous than marijuana, but in the eyes of the federal government, it is not. Schedule 3 includes other things like steroids, such as testosterone, Tylenol with low doses of codeine, and other drugs. And so the interesting part about Schedule 3 is that things that are on it are much more easily brought to market than things on Schedule 1. In the 1960s or 1970s, ketamine was approved by the FDA as an anesthetic, and it's been used in medical settings both for humans and for animals as one ever since. It's also been used for a host of off-label uses, and I read statistics that say this is not something that's unique to just ketamine. Off-label uses happen with basically any drug, and so much so that apparently 20% of all prescriptions are based on off-label uses. But with ketamine, it's been used as an off-label drug for a number of years for things like depression and other mental disorders. But last year, towards the end of 2019, the FDA approved the nasal spray of a drug called Is Ketamine, which is very similar in structure to ketamine. The brand name is Spravato, and that's specifically used for treatment-resistant depression. I will sort of caveat this by saying it's not like medical cannabis where there are a host of different ways to obtain ketamine treatment, medical cannabis in some states, you can have chronic pain and get it. It requires actual physician recommendation, prescription for administration, and to get Spravato, specifically the nasal spray, a person has to have had 2 forms of treatment for depression that failed first. So it's a high threshold for people to receive this treatment, at least for the approved on-label use. Also in the United States, ketamine's been used for decades as a club drug. Anyone's heard the name Special K? That's a reference to ketamine.
And specifically, and this again makes it different from these other emerging medicines, including cannabis. How is it administered, and what state and federal agencies are involved, since we're dealing with actually a highly regulated Schedule 3 controlled substance?
So when it comes to Spravato, I said it's a nose spray, but it's not like Flonase where someone gets a prescription and just brings it home and does whatever they want with it. They actually need to self-administer it under the care of a physician in a doctor's office. They can't take it home. They have to stay there for a couple hours after using it. The healthcare provider needs to monitor them, make sure that they don't have any serious conditions. They're not allowed to drive after doing it. So it's very seriously regulated. Forms need to be filled out, things like that. If it's an anesthetic, similarly, people are being used to be put to sleep, so they're not taking that home to inject it. All of this is happening in a very, very medical setting, which is different from cannabis. I can't speak for all states, but here, in order to receive cannabis in California, you don't even get a prescription. It's just a doctor's recommendation. Doctors don't administer this at all. You just get the written recommendation, take it into a dispensary, or you get your medical marijuana ID card. But with this, it needs to be done in a medical setting. I think you also asked the agencies that are involved, and there are many. From the top down, we start with the DEA, Drug Enforcement Administration, which essentially enforces the Controlled Substances Act and regulations thereunder. If you're a physician that administers drugs that are on Schedule 2 or 3 or other schedules, you need to have a DEA registration, specifically to every location from which the drugs are administered. These are somewhat complicated to obtain, and really only physicians or certain other medical professionals, hospitals, things like that can get them. So just the average Joe is not going to be able to get a DEA registration to start administering ketamine to people. Food and Drug Administration, as I mentioned, has approved certain drugs. If anyone wants to approve ketamine for a new use, while it's been regularly administered to patients for off-label uses, say a company wanted to market it for a new use, it can't just do that. It needs to go get the FDA approval. So they would go to the FDA to seek that approval. And then finally, since it's medical professionals who administer these drugs, state medical boards, nursing boards in some states will issue licenses to those doctors. They're not necessarily tied to the administration of ketamine, but it's just like an attorney being barred in a state, right? They have to have a medical license or the equivalent in whatever state to practice medicine. And in some cases, maybe a certificate by a board for a specialty in anesthesia or something like that.
Now, a lot of people who call us want to know, how do I set up a ketamine clinic? What are the corporate ramifications? Can I even own it if I'm not a physician, given that this is a Schedule 3? It's got to be administered and overseen primarily by a physician making the clinical decisions around the treatment, around the patient's well-being. What can we do here to make this a viable business venture, basically?
Well, I'll start with talking about who can own a ketamine clinic. As I mentioned, ketamine clinics are composed of physicians, right? They're the people who can administer this, but logically you might think, well, if the physicians are working for the clinic, can I, just as a regular person, own the clinic? And the answer is, it really depends on where you are living, right? This is what's referred to as the corporate practice of medicine, and states take a drastically different approach to who can be involved in medical corporations or other medical entities. California, where Hillary and I lived, is a strong state when it comes to prohibiting corporate practice of medicine by non-physicians, with very, very limited exceptions. Non-physicians can't own medical corporations, and so then they can't really otherwise have any sort of say over how they're run. So in a state like this, basically those opportunities are left to physicians and physician-owned companies. That said, there can be some business opportunities for non-medical professionals in the ketamine space. And this is a concept called the Management Service Organization model, the MSO model. Basically, it's very similar to some things that happen in cannabis. The licensed company here, in this case, the physician entity, will enter into a relationship with a management company that will manage certain aspects of the business of the physician group. But I want to be very cautious and say that these are very, very highly regulated, these two relationships, and it also depends highly on the state. California, for example, the medical board here has published guidance on what an MSO can and can't do, and it's basically anything that the doctor should be doing, the MSO can't do. So, for instance, the MSO can't make decisions on treatment or diagnoses or how records are maintained or marketing decisions, things like that, right? That all needs to be left to the doctors. They may be able to assist with carrying certain things out that are non-medical in nature. They may be able to provide administrative support, real property, some cases intellectual property, and things like that. But the role of an MSO is much more narrow than it could be with, say, a cannabis business, where a lot of times management companies have sometimes total reign over the company if they're properly disclosed to the state.
Okay, well, you've heard it here. One of the popular models that we see run parallel with the ketamine clinic. This is where a lot of the venture money goes. This is where a lot of the business development is in the management services organization. And there are multiple different models with MSOs that can be set up with professional medical corporations. It is heavily state dependent where you're at as far as how dynamic that relationship can be, including the consideration between the parties for services and control over various business decisions. To echo Griffen, California, Texas, New York were very strict anti-corporate practice of medicine states, which means the docs primarily have to be in control of their business fate. There are other states where that is not necessarily the case, and it could be a more lucrative venture. Having said that, there's lots of ketamine clinics here in California. Seems like they're popping up all the time. And there's more than 600 at this point in all of the United States, which is pretty crazy, given that this is an off-label application. With the time that we have left, which is about 10, 12 minutes, I want to move to Jesse, who's actually our primetime litigator on the panel, to talk about the liability issues stemming from these new drug therapies. We've all seen it in cannabis as an emerging market. Once it stabilizes and people get down to business, people fight. There are breaches of contract. There are partnership disputes. There are liability issues regarding, frankly, medical malpractice, other liability issues around fatal injuries, even death. So we have to talk about that. We'd be remiss if we didn't. With regards to ketamine and new drug therapies, Jesse, have you seen any federal or state enforcement actions to date that people should be aware of? Jesse, I think you're on mute.
Sorry about that. Thank you. I have not seen any state or federal enforcement actions to date, but that's not to say that I might have missed something at the state or local level. And I think that, if the ketamine clinics continue to expand at the rate there are, and it is certainly, a burgeoning business model around the country, that I think it's sort of a matter of time, a when, not an if it'll happen.
What about any private claims out there regarding new drug therapies?
Yeah, so I think you've touched on it briefly, but the big thing that we've seen with the ketamine clinics so far are kind of akin to the medical claims of the medical malpractice variety. And so, this is something that any physicians or medical professionals are on the line, I'm certainly are well familiar with. But we've seen these kinds of lawsuits here in Oregon, New Mexico, Texas, Pennsylvania, and so It's easy to think, well, I'm not a doctor, this isn't going to affect me. But I think that's where we get into the key considerations when we're talking about these kinds of businesses and these kinds of ventures, and whether it's a psilocybin or ketamine or another emerging therapy. This is where I think the liability, risks you really have to take a strong look at these risks at the outset of the venture. And so I can kind of talk about sort of like that a little bit and sort of my thoughts on people who are moving into these spaces, you've got the risk of the medical malpractice lawsuits is obviously huge. But, we've got to look at that. If a plaintiff's attorney, and I don't do those kinds of cases, but if someone's going to bring that kind of lawsuit, they're also going to bring that lawsuit against the business. And so, that means that comprehensive and robust insurance policies are going to be essential for any business that's looking to move into this. I think a third thing, and this is critical, is that you need robust corporate governing documents for, if you're on the investor side of this. Let's suppose you're not on I'm on the ground level on this, but you want to be the silent partner. You want to provide some financial backing, whether to its family member or a third party. You really want robust governing documents on that investment. That's what's going to help minimize liability in the event of any lawsuit. And you've also got to operate the business like a business. And in the legalese terms, that's called sort of maintaining the corporate formalities. But one of the things that I think, you'll start to see with these are plaintiffs' attorneys saying, okay, well, let's not just go after the company. Let's not just go after the doctor. Let's see if we can, pierce the corporate veil, it's called, and go after the actual personal assets of the investors here. And the way to prevent, and there's ways to really, nip those kinds of claims in the bud, but that's where you really want to work with your corporate attorneys on developing the documents and how you're going to structure these businesses. I think also what's going to be important is, what kind of defense, indemnity, and liability hold harmless provisions do you have in your contracts? How can you structure, if you've got a number of different sites, how can you structure your business so that if something happens at one clinic, that's not going to carry over and maybe take, affect all of your other holdings? Turning briefly, we're running out of time here, but briefly to the, IP34, for manufacturers on that side, you're going to face the same kind of risks you do with any other product. Product liability lawsuits are going to be a real thing. And I think having strict controls in how you're developing those products is going to be really important. I think another thing that when we look at IP34, we saw this in cannabis, is that when investors are looking at going in the marijuana market, you'd see a lot of investment made into companies or businesses that didn't have a license yet. And then, maybe months or years go by and nobody gets a license. Okay, well, what happens then? And these are all kinds of problems that I think can really be dealt with. From my perspective as a litigator, it's a lot, it's great to have these kinds of cases. They're always really messy and, they're going to generate a lot of legal fees, but you can solve so many of these problems if at the outset of this, you sort of take the time to, hire a good corporate attorney to really take a look at what you're planning on doing. How are you planning on going about it? Your attorney, the people are always excited that this is going to be great. We're going to make lots of money. And the attorney's going to tell you, here's all the potential risks and problems, and you need to take those seriously. And I think especially in these emerging markets where the regulations are uncertain and, the risks and potential bad outcomes, especially when we're talking about the practice of medicine here to some extent, is pretty serious. So I'd sort of stop there so there's time for questions or anything else.
Yeah, I want to echo that, what Jesse said about having good documents. You want that in any business relationship to prevent and kind of guard against any litigation issues, to quarterback what's going to happen with the parties. In the ketamine clinic setting, because we're dealing with MSOs and medical professional corporations, the main document is a management services agreement, and it needs to heavily detail compliance around the anti-corporate practice of medicine practices, because 9 times out of 10, when that relationship goes south, one of the parties is going to say that the other one violated corporate practice of medicine prohibitions and really try to stop the enforcement of the contract because maybe fees are owed or there are other performance obligations that the other party just doesn't want to bear anymore. And if that goes before the medical board or winds up in court, you are going to be very sorry if your management services agreement did not address those particular issues. So that's very specific to ketamine. With psilocybin, I think it's kind of unwritten as to what we'll see. I imagine, though, it's going to be run-of-the-mill like anything else with partnership disputes, IP disputes, investor relationships gone bad, probably medical malpractice since physicians are going to be implicated. And we know very little, frankly, about this drug and what it can do. With the time that we have, it's only about 5 or 6 minutes. We're going to take some questions, obviously, from viewers. I do have one, and this one's for Vince. What else have we seen in the emerging, new drug therapy space? In particular, what's going on with Kratom these days? I feel like that was a buzzword maybe a few years ago. Is it resurfacing? Is it making a comeback?
Kratom, yeah, Kratom's interesting. It's a plant medicine. People commonly talk about it. It's an herb. It grows in Southeast Asia. The way that people use it in the U.S. and have used it there and elsewhere for a long time is to treat opioid dependence. So Kratom, different than some of the drugs we've been talking about in that it's not scheduled. It's not illegal federally. It's illegal in a handful of states, like 5 or 6 states, something like that. There was a push maybe it wasn't even that long ago, 3-4 years ago, by DEA to consider labeling Kratom as a Schedule I drug on FDA referral, I think. And there was a bunch of pushback and a big brouhaha. And ultimately, they didn't do that. The pushback, interestingly, came from inside the government, too, because, if you list a drug like Kratom on Schedule I, you really stymie research into it. And because it has promising opioid treatment withdrawal applications, it's kind of maintained its status quo non-scheduled listing. That said, the FDA doesn't like Kratom, just like it doesn't like a lot of things. It says it's concerned about safety. And if you go to the webpage on Kratom, it says, we're concerned that this affects the same brain receptors as morphine, and it has properties that exposes users to risks of addiction, abuse, and dependence. So the FDA's view is that, it might wean people off opioids, but then here they are addicted to Kratom. There have been relatively few formal Kratom studies, which seems strange because it's so prevalent, but that's just kind of the status quo on it. There are other new drug therapies, too, you asked about, that are out there being studied. It's all exciting. There's Mdma Ecstasy. That drug has been studied fairly extensively, mostly through MAPS efforts in the context of treating post-traumatic stress disorder. If anybody's been in and around this space, you've heard of MAPS. It's a multidisciplinary association for psychedelic studies. They've been around forever. They took MDA-assisted psychotherapy through demanding phase 1 and phase 2 FDA trials. They're currently in phase 3 FDA trials. And that's a notoriously rigorous phase where drug development companies have to confirm and expand on safety and effectiveness results they've got from earlier trials. From what I'm reading, the data looks good for MAPS so far, and they're on course to meet FDA's efficacy requirement for approval as a legal prescription drug. So we may see an MDA drug at some point in the next few years. People have been looking at ayahuasca. People know that's an entheogenic plant that grows native to South America. DMT is the principally active ingredient, dimethyltryptamine. It's different kind of drug in that it's got a hallucinatory or psychoactive effect that's quick up and quick down, lasts about 30 minutes. There's a company called MindMed that's sort of big in the space that says they're launching a phase 1 trial for that in Switzerland. Somebody asked about Ibogaine, I can see in the thread. Ibogaine's a West African herb that is under a phase 2 clinical trial, again with MindMed, supposedly to treat opioid addiction. I think that's an FDA trial, but right now Ibogaine's more problematic to study than some of the drugs like Kratom because it's a Schedule I controlled substance. So you can see that there's just a lot going out there. This is a really interesting space. Wellness is a big thing. There's a lot of concern these days with mental health and mental health solutions and treatments, and it's a big market. And we talked briefly about what the market would be like just in Oregon, but it's going to be big elsewhere, right? People don't think of it like this a lot, but it's a tech space, I would say. People are working really hard on everything from technologies to grow entheogenic plants like psilocybin mushrooms that dose the same and have the same plant profile every single time, to isolating these compounds. There's heavy investment into things like virtual reality simulators and other immersive media experiences to attempt to mimic or enhance these experiences. People are applying for patents to protect these things. And, the government is into it. The FDA is into it. We had news last week that the U.S. military allocated $17 million for ketamine and psilocybin research that's going to be conducted at the UNC School of Medicine. So you're going to be reading more and more and more and more about this as wellness is in the spotlight and as these drugs are proven to have efficacy. And it should be an exciting time for entrepreneurs, lawyers, policymakers, everybody in the space.
Does anybody think that any of these new drug therapies will ever be exercised for recreational use, like what we've seen for cannabis in adults 21 and up? Is that on the table?
They already are. It's just not legal. They have been for years.
Right.
Yeah, but I think you'll see broader decriminalization in Kratom already is, and that's not used so much recreationally. But yeah, I think it's kind of a wearing away at the old guard of let's heavily control these things without even thinking about it, and they're going to kill everybody. And it's culturally, socioculturally we already have that drug use. We're going to accept it a bit more politically as a matter of law. And I just think there's a slow paradigm shift.
Got it. Well, I want to thank you guys for participating today. We really appreciate your attention and your insights, always super valuable. We're at the 1 o'clock hour Pacific time. Everybody, thanks for joining us. And do not forget to join us again for yet another free webinar on August 5th. This time, and Jesse will be involved, and so will Griffen. The topic's going to be emerging trends in cannabis litigation. Super enthralling stuff to help you protect yourself in an emerging market. From Harrisburg, we thank you all very much, and we'll see you next time.